We are coming to you live and direct from the Peacock Alley American Grill and Bar in the famous Patterson Building in downtown Bismarck, North Dakota. Live on 550 K-Flyer, AM 1100 The Flag, and AM Talk Radio 1090 KTGO in the Bakken. Another night number 2 of the Legislature Today radio show. Thank you for listening. Thank you for watching at GreatPlainsNews.com. And you're in for a fine treat today, recapping day 1 of the North Dakota Legislature. We'll be chatting with Chief Justice Gerald Vandewalde, North Dakota's judicial system and the State of the Judiciary speech, which will be coming up tomorrow in our focus in this hour.
How does one become the Chief Justice of North Dakota? Could you explain how that happens?
Well, our Constitution provides that the Chief Justice is elected by the justices and the district court judges of the state. We're the only state in the union that does it that way, where the trial court judges vote for the Chief Justice as well as the justices.
What was the logic of doing it that way?
Well, it was before my time, but prior to that time, it turned over every 2 years. The justice holding the shortest term was the Chief Justice for 2 years, and then it's passed, and the idea was that there should be more of an administrative continuity than there was.
Was it something that you aspired to when you joined the Supreme Court?
No. No, I just thought I was very fortunate to be the young pup on the court at that stage of the game. The next youngest on the court was 11 years older than I was, and the rest were all older than that. So,
was this a situation where I presume that a lot of us who have served in volunteer organizations, you leave the room and you get elected to the board? It's a job that people don't want.
After a while, it became, people just accepted the fact, and I did, I was going to be it. There was no real discussion. It was just assumed. I don't know how that happened, but it did. Well, some of the people left. Died and retired, so there were new people on the court.
What does it mean to be the Chief Justice? What do you have to do that the other justices
don't have to
do?
Under the Constitution, the Chief Justice is the administrative head of the system, and that's really the reason that the trial court judges vote. We're a unified system, so the administration part is part of the what they do. I don't think that trial court judges care who the ceremonial Chief Justice is, but they do care who the administrative judge is, because we are a unified system now.
And because you're the Chief Justice, do you have to do things like, testify before the legislature and essentially represent the judicial system and other branches of government?
Yes, you do. You do. And tomorrow is the State of the Judiciary, which is not provided for by the Constitution, but the legislature has kindly invited the Chief Justice for a number of years to do that.
How do you write the State of the Judiciary speech? How does it take shape?
Well, I do have a state court administrator that helps me with it, and we talk about what the subjects we're going to discuss, what we should discuss, things that we should be asking for. I consider it, Dale, as not a huge time for philosophy, but more of a time for a report to the legislature, the executive branch of the people in North Dakota of what we've done, where we are, and where we want to be.
Without going through your whole address, of course, what do you think you're going to be saying tomorrow that the legislators are going to be the most interested in?
Obviously, a request for new judges and new employees will be of interest to them. It always is, because it's additional money, and it should be. There are some other parts of it that I think they will find interesting. What we're doing in the family law area to try to reduce the animosity between the parents of children. Some things about providing access to the courts for the unrepresented people.
And could you talk a little bit about, first of all, how many judges are you asking for? How many additional judges?
3.
And where would they be located?
2 in the Northwest District, which is Minot, Williston, the most heavily impacted area from the Bakken, and then the third one would be in Fargo. Fargo has been showing a shortage of judges for some time, but until this year, there was no room to put an extra judge, and they have now opened their very, very nice new addition to their courthouse, and so they now have the room for that additional judge. It doesn't do any good to put an additional judge in where they don't have the facilities, because if they both can't, if all the judges can't be hearing at one time, it doesn't help. So.
Maybe 20 years ago, there was a procedure by which a number, well, I don't recall exactly how many, but there were some judges in the Northwest District in the northwestern part of the state whose jobs were eliminated as part of a unification plan. How does that look in retrospect?
Bad. If I had any kind of prescience, we would not have moved the judges out of Watford City and Minot, Watford City and Stanley into Minot, but we were faced with reducing the judges, the number of judges over a period of 10 years, and we cut where we had the opportunity to cut.
Could you just talk about why is it important that, I mean, your budget includes 3 judges, I think 7 clerks at least. I don't remember exactly how many, but it's a fair number of new employees for the court system. Why is it important that you have those?
Well, for a number of reasons. Number one, a speedy justice is part of the constitutional requirement, particularly in criminal cases, so you can't delay them. Speedy trials are a right of constitutional right. There are some other more pragmatic reasons. I think if you take a look at any survey of court systems by business, as an example, a business climate in a state, part of what they look at is how expeditious the court is in disposing of their cases. That's part of what they look at as far as gauging the business climate of a state. That's just an example. In family law cases where we've got kids hanging between 2 parents, we need to speed that up. We can't let that go on. So.
There's been a trend recently, in recent years, to establish, they are called problem-solving courts, specialty courts. We have specialty courts now for drug cases. We have family mediation services. How do you think that those are working, and is that a trend that can be extended to other areas of the law?
It can and has been expanded in other states quite a bit, Dale. They have veterans courts, reentry courts, mental health courts. All those are specialty courts, and they work simply because it's a combination of people, executive and usually the judicial branch with the support of the legislature that focus on there. The judge is just one part of that. There's treatment providers, there's counselors, there's all those people, and it works because it's a one-on-one type of thing. I've said before, if every child had a tutor, we wouldn't need no child left behind law because they would be educated. We can't afford that, but that's why specialty courts work, is they put attention on the individual.
We're coming to you live from the Peacock Alley American Grill and Bar in downtown Bismarck. Legislature Today. Our radio show continues. By the way, you can watch us at GreatPlainsNews.com and also submit your questions there. We do have a question for our guest, the Chief Justice of the state of North Dakota, Gerald Vanderwall, is with us on the program. And the question for you, Judge and Dale, before we turn things back over, has to do with easier if I actually could find the question and repeat it to you. You want to ask a question while we're waiting for the listener's question?
Sure.
I had it a moment ago here, but
how did you come to be appointed to the Supreme Court?
Well, I'm a great believer in being in the right place at the right time, Dale. You have to be ready to seize the moment. I mean, you can't sit back and not do anything. But I think I was in the right place at the right time. I hadn't really thought of applying. Some people urged me to, and I took a look at the list, and I thought, well, why not? And so I did.
Did you know Governor Link well?
Yes, I did. I was the attorney for the Industrial Commission Oil and Gas Division for almost 20 years. They created, that's why I stayed in the AG's office. The 1959 legislature created that position, and they offered it to me, and I stayed. But I did a lot of other things, and one of the things I had done for Bill Guy when he was governor, because there was no legal counsel in his office at that time, and he asked the Attorney General for some help in the bill, going over the bills for the office and for his office. And they sent me over. I suppose I was the least threatening. I was the most non-political of the bunch. And I did the same thing for Governor Link when he became governor.
Would you described yourself as the most non-political of the bunch. So Governor Link appointed you even though were not a... Did he know whether you were a Democrat or not?
No, I don't think the Attorney General knew what I was. I was never asked. The dean picked me to go to the Attorney General's office. I went there. It was a one-year appointment. I stayed. I will say I was loyal to my bosses, who were Republicans, and really gave me a lot of freedom. They took all the heat, and I got to do a lot of the work, and so it was a good time from that. But no one ever asked me.
Which attorney generals did you work for?
Les Burgum, Helge Johannesson, and Al Olson. And
can you describe what each one of them was like as a boss?
Well, Les Burgum was a Methodist minister, a very fine man, very not conservative in his attitude towards people, but certainly conservative in his own habits, as you might expect a minister to be. He paid the salary according to whether you had a family or not. I didn't have a family; that didn't sit too well. But and then Helge Johannesson came in, and Helge had been Les Burgum's first assistant, and was a little more liberal on the salary issues perhaps than Les had been, but also was didn't require any political activity contributions from any of us. It was never asked. I'm sure he expected loyalty, but that was it. In fact, we were told at that time, you do the work and leave the politics to us, and that was the thing we went by.
We're talking to the Chief Justice of North Dakota, Jerry Vandewalle, and he's going to be giving the State of the Judiciary speech to the North Dakota Legislature tomorrow.
I do have that question, Dale.
Let me roll here for a second. He'll be giving the State of the Judiciary speech to the North Dakota Legislature tomorrow, to a joint session of the House and Senate. And what is the question, Scott?
It is from Alice. Alice asks, how can the courts be a check and balance on the other two branches of government while embracing the principle that acts of elected officials are presumed to be constitutional? It's way above my pay grade, but that's why you're the Chief Justice.
Well, there's only a presumption. It doesn't mean that they are absolutely constitutional. It is the check and balance, and the person asking the question obviously knows that that's what the court is for. It is to determine the constitutionality of acts of the legislature, as an example. There is a presumption of constitutionality, but that I think Bob Vogel, who I succeeded on the court, put it well when he said, if you're going to attack the constitutionality of a statute, you need to bring up the heavy artillery. In other words, you don't just throw, this is unconstitutional around, this is unconstitutional, that's unconstitutional. You have to prove it, and that's why there's a presumption of constitutionality, to put the challenger on its proof. A lot of people in North Dakota may not know, I shouldn't say that, some people in North Dakota may not know, this is a populous state, and it takes, the legislature is the people's body. They elect them directly and by region, and it takes not a simple majority of the court, but 4 of the 5 justices to declare a law unconstitutional. It's a supermajority.
So would it be a flawed premise to suggest that just by legislators saying we're voting this way, it's presumed constitutional? Is it more a case if you're going to challenge it, you need sort of the solid X's and O's arguments of why it's not constitutional?
Right. The people's branch of government has enacted this law. You're challenging it. You tell us why it's unconstitutional. There's a presumption that the people have enacted a constitutional law, and of course the same thing applies to the initiative laws. It's the same thing.
Why do you think that the State of the Judiciary speech is useful?
Well, as I said earlier, I think it's a report to the people of what we've done, where we're going, where we are, and where we hope to be, with some changes in the judiciary. And I'm not talking about numbers now. I'm talking about in the way we handle cases. There's no doubt about the fact it's a changed a changed environment for trying lawsuits. We don't try a lot of lawsuits anymore compared to what we did, and so it's important that people understand what's out there and what's going on in the judicial branch.
Why the change that you just mentioned? We don't try a lot of lawsuits as we once did. Why is that?
Well, I should say the number of jury trials is down. We still try a number of lawsuits. The number of jury trials is long. I've been told, I don't have evidence of this, that it's probably due to the cost of trying a lawsuit. It's easier to try to settle it, and that. And there are various ways of resolving disputes. Alternative dispute resolution has taken over, arbitration, mediation, some of those things, and so they're all coming into the court system.
Could you just take us through how the Supreme Court handles a case? Someone files an appeal. What happens?
Okay, we have a set of rules, and so the rules apply, and they must provide a record of what took place in the lower court. The appellant must file an appellant's brief and an appendix which contains the major documents in the case. The appellee, then the one who won below, files a response to the appellant. The appellant then has a matter of days to file a reply brief to that, and at that time it's set for oral argument. Now, oral argument can be waived at the request of the parties, or on occasion the court will simply say we don't need oral argument in this case.
And how big of a role does oral argument play in a decision?
It plays a role. I will tell you a story that when I came to the court, I came in the middle of the summer, or I came in the middle of August, and the others had already started working on cases that they hadn't heard yet. I mean, they had been filed, and of course I was behind. And so by the end of the next year, I was behind. I had to speed up to try to get caught up that. So I thought, well, okay, I'm going to get a head start on these cases. And I had started drafting an opinion in a case, and it was pretty well drafted before oral argument. I went into oral argument. I came out of it, oral argument, I tore the draft opinion up and rewrote it with a different result. So I never underestimate the effect of oral argument.
How are cases, well, who decides, how is it decided who writes an opinion on a particular case?
Yeah, in many states the Chief Justice does that. I do not. We have no intermediate appellate court, so our caseload is it's like a hydraulic press. The cases just keep coming, and so the clerk automatically assigns every fifth case to one of us.
And is there any ability for a justice to say, well, I want that case?
No.
Do you specialize in anything,
No.
any particular type of case?
No.
Okay.
In fact, I had the education portfolio was one of my big portfolios, elementary, secondary, and higher education. We were hearing some education. I didn't get an education case for 2 years.
Do you think that the court should be larger?
No.
Why do you think 5 justices work?
I don't think that, I think 5 justices work because it's enough of a balance to give various ideas and thoughts and positions, and yet it's not so large that you have to deal with all these other people and their opinions that are coming in. It slows the process down. It doesn't speed it up. It slows it down. And so, I think 5 people pretty well will cover the waterfront that 7 people would do. Some people have suggested, well, you have to write, that way you write less opinions per justice. You do, but that's made up for by the fact you have to deal with people's visions back and forth, and so.
Do you have discretion in which cases you take?
No.
And do you think that's a good system?
Yes. We have no intermediate appellate court, so if we had discretion, some cases would never have the right of appeal. Now, there's not a constitutional right to appeal, so it's not a constitutional issue. But I think that there ought to be some review of a one-judge decision, and so yes, I think that there should be a review, and without an intermediate appellate court. No. There is there would be no right to that appeal if it didn't come to us. Now, there is what we call supervisory jurisdiction, an original jurisdiction, that in which the supervisory jurisdiction is the case is not appealable, but they're asking us to supervise the district judge. That's discretionary, and so is the original jurisdiction, where they come right to the Supreme Court on a matter without going through the trial courts. That's discretionary, except in the instance of initiated and referred matters. The Constitution says we must hear that directly.
And can you tell me how you arrive at the result of a case? If you describe the conference process.
Sure. The author, assigned author who's assigned ahead of time, will write a rough draft. That rough draft will be circulated among the other justices. The other justices will make suggestions. There may be some discussion back and forth. Occasionally, there will be special concurrences and dissents. And we have conference days. We meet in a conference together on those days. And if the dissent gets 2 more votes, then that person will write the majority, and the original majority writer ends up writing a dissent.
Do you all meet in the same room and discuss cases? How does it work?
Yes.
And how many cases do you discuss at once, at one sitting?
It depends. First of all, after every oral argument, there is a very brief discussion of that case. It is not an up and down vote. It's just a very brief discussion of where we think we are in the case. After the opinion comes out, then it depends on how many cases are on the agenda for that conference day. There can be 15, there can be 30. It depends on how many come out.
And how long does it take from the time the result of a case is known to the time it's announced publicly?
Well, it's the same day.
Okay.
Once the result of an opinion is not known until the signatures are actually on the opinion. So and those are released immediately the same day.
The environment in which you work, can you describe how it was when you first came in? Like, how did you have a clerk? How did you have a staff? And how is it different now?
Well, I did have a clerk. 5 justices each had 1 clerk, and I had a clerk. We each had a secretary. There were 2 people in the clerk's office, and there was a librarian, and there was a court administrator. But we didn't have a unified system at that time, so that was pretty well the court staff. We then went to ask for additional law clerks, and the legislature gave us 2, and that we rotated those among the 5 justices. That didn't work too well, and so Chief Justice Erikstead set up central legal staff. He took the 2 positions of the roaming law clerks and a staff position, and he then set up central legal. And so we now have central legal as well as our clerk staff. There was not as much discussion among the justices when I came to the court on opinions as there is now. I was told by one of the justices, very frankly, when I went in to talk to him my first month about an opinion he'd written, he was very gracious to me, but when I left, he said, Jerry, usually we reserve that for the conference room. And I said, well, if you've got any questions on my opinion, I hope you ask me ahead of time and don't wait till I get into the conference room on conference day. But that was the way it was.
Do you think that lawyers who come in to argue cases before you are intimidated?
Oh, I suppose some are. I was the first time I argued, sure. Although the court didn't ask any questions in that case. But I would imagine some are. Some have stage fright. So yes, I don't know if you mean intimidated by the court. I think they're nervous and they're
intimidated by the experience, actually.
Probably the first time. Yeah, I would get. Although now they see us in action at the court. In the law school we judge moot court competitions, so they're used to us. At least the North Dakota law students are used to us.
What do you think about the fact that your filings are available on the internet? People can watch oral arguments on the internet. The court is because of technology, the court is a lot more accessible than it once was. What do you think of that?
I think that's good. I approve it. There are some downsides. There are some people that we see a lot more self-represented people now than we did, and some of them are capable, some of them are not capable, and it's problematic for our clerk's office particularly, because they get a lot of questions from these people. How do we do this? How do we do that? How do we do something else? I don't think that happened when I came out of law school. You didn't see any self-represented people.
What are the toughest types of cases that you handle?
I think family law cases are the most difficult because very seldom is there a right and wrong answer. And so the courts, I think the adversarial process works well in every instance except family law cases, particularly child custody cases. We tell people, I've read hundreds of transcripts over the years, and at the end, the judge makes a decision and says, now you two have to get together because you share parents of this child. You're going to have to communicate with one another. It's very difficult after you've thrown every negative thing that's happened all during the marriage out on the table. And I've said before, truth is something that we seek in the justice system. I don't know that absolute truth in a marriage is always necessary. I don't think that the fact your husband looks like the cat dragged him in when he gets up in the morning, you have to tell him that. I mean, it may be the truth, but I just don't think you have to tell him that. So I don't mean to be humorous about it or treat it lightly, but I just think that there are some things that have to be overlooked, and they very seldom are where it's tried in an adversarial case.
We have another question from one of our listeners, GreatPlainsNews.com. GreatPlainsNews.com to ask your questions. We're live from the Peacock Alley American Grill and Bar, the Legislature Today radio show on K-Fire 550, AM 1100 The Flag, and AM Talk Radio 1090 KTGO to the Bakken. More questions from our host, Dale Wetzel, with our guest, the Chief Justice of the great state of North Dakota, Jerry Vanderwall, with us. Wants to know your favorite Supreme Court justice. You have a favorite, Judge?
U.S. Supreme Court Justice? Oh, probably John Marshall. He was the one that really cut the quick on the separation of powers issues and some of those issues. I'm a great defender of separation of powers, and he's the one that really, I think, started it. Yeah.
One of the things, you like to play bridge. Why do you like to play bridge?
Again, I like the structure of it. I like the competition. It keeps my mind sharp, and the one thing it does is it's the most the best game I've ever seen. I don't care who you are, what position you hold. It's how you play those cards that makes the difference.
So in other words, you can be the guy on the street corner or the CEO of a huge company,
or the Chief Justice. And I've had my partner look at me and say, "You dummy." So yeah, I like it, and I like the structure of it.
Well, we've been talking to Chief Justice Jerry Vanderwall, who's going to be giving the State of the Judiciary speech tomorrow in a joint session of the North Dakota Legislature. Thank you for coming to see us.
You're welcome. It's been a pleasure. It's been fun.
Thank you.